So this is the city's response to my motion for a new trial. This was not argued while I was in jail, and it's just been kind of set aside. So it's written, but it really was never discussed in court. May it please the courts, comes into courts of the city of Natchitoches through the prosecutor Cloyd Benjamin Jr. He respectfully submits this memorandum in opposition of defendant's motion for new trial. Louisiana Code of Criminal Procedure, Article 853, time for filing motion for new trial. Article 853, time for filing motion for new trial. Except as otherwise provided by this article, a motion for a new trial must be filed and disposed of before sentence. After conviction and before sentence, this court on motion of the defendant and for good cause shown may postpone the imposition of sentence for a specified period in order to give the defendant additional time to prepare for and file a motion for a new trial. When the motion for a new trial is based on Article 851b3 of this code, the motion may be filed within 1 year after verdict or judgment of the trial court, although a sentence has been imposed or a motion for a new trial has been previously filed. However, if an appeal is pending, the court may hear the motion only on remand of the case. When a motion for a new trial is based on Article 851b6 of this code, the motion may be filed within 3 years after the verdict or judgment of the trial court, although a sentence has been imposed or a motion for a new trial has been previously filed. However, if an appeal is pending, the court may hear the motion only on remand of the case. Defendant's motion for new trial is untimely. Defendant's trial was heard by the city court judge on April 11th. 14 days later, defendant now requests relief for which he is not entitled. For this reason alone, the motion for new trial should be denied. Although Travis Hines chose to represent himself, he is no stranger to filing motions. He has filed a number of motions in this proceeding. The rules are the rules and equally apply to the defendant. Defendant is entirely capable of filing numerous motions and could have timely filed a motion for new trial. Defendant argues that the availability of Code of Criminal Procedure, Articles 873. Article 873, delay between conviction and sentence. That was 3 seconds. If a defendant is convicted of a felony, at least 3 days shall elapse, not may, shall elapse between conviction and sentence. If a motion for a new trial or an arrest of judgment is filed, a sentence shall not be imposed until at least 24 hours after the motion is overruled. If the defendant expressly waives a delay provided for this in this article or pleads guilty, sentence may be imposed immediately. Defendant waived his rights by indicating he desired to move directly into sentencing. Oh yeah, there is no pro se defendant exception to the Code of Criminal Procedure. Justice was served in a trial that lasted nearly 7 hours. Although a defendant argues that his pro se status avails him to a new trial, he cannot point to a single instance under Article 851, grounds for a new trial that allow a new trial based on adequacy of representation. Defendant's indigent status, or lack thereof, was determined by this court during a hearing with prosecutor Methvin on April 4th. There is no need, or April 6th. There is no need to relitigate the issue of indigency at this time. In fact, the grounds for a new trial does not allow relitigation of the constitutional arguments. A law enforcement officer may stop a person in a public place whom he reasonably suspects is committing, has committed, or about to commit an offense and may demand of him his name, address, and an explanation of his actions. In Louisiana, a law enforcement officer may stop and question a person in the public place whom he reasonably suspects is committed, has committed, or is about to commit a criminal offense. In Article 215.1a, to justify an investigatory stop, an officer must have reasonable suspicion of criminal activity. State v. Boss in 2004. Reasonable suspicion, which is something less than probable cause to arrest, requires that police officers have sufficient knowledge of facts and circumstances to justify an infringement of the individual's right to be free from government interference. State v. Chauvin. Absent reasonable suspicion, an investigatory stop is illegal, and the evidence seized as a result is inadmissible. The determination of reasonable grounds for an investigatory stop does not rest on the officer's subjective beliefs or attitudes, but is dependent on an objective evaluation of all the circumstances known to the officer at the time of his challenged action. In determining whether the officer arrested reasonably in such circumstances, due weight must be given not to his inchoate or particularized suspicion or hunch, but to the specific reasonable inferences that he is entitled to draw from the light facts of his experience. An anonymous tip may provide probable cause for an arrest, Illinois v. Gates, or reasonable suspicion for an investigatory stop, Alabama v. White. If it accurately predicts future conduct in sufficient detail to support a reasonable belief that the informant had reliable information regarding the suspect's illegal activity, State v. Smith, citing Alabama v. White, Louisiana revised statute of 14108 is a constitutional pursuant to Terry v. Ohio and subsequent cases involving investigatory stops. While this court may make a determination regarding the facts alleged by the state and whether the facts support the charge, there can be no doubt that the charge of resisting an officer by failing to identify oneself, wherein an officer has reasonable suspicion to detain, is constitutional. At trial, Favors, Davis, and Miller all established reasonable suspicion and probable cause in hours of testimony. Defendant incorrectly asserts that he was prejudiced by the playing of witness interviews from the library. Defendant requested that the videos be played to the courts. That said, defendant appears murky of facts of the proceedings leading to his conviction. Nevertheless, no grounds exist for a new trial. Therefore, the City of Natchitoches respectfully requests that motion for new trial be denied. Respectfully, the Cloyd Benjamin. I hereby certify that a copy of the above has been served. And yeah, that's it.